I can call Mr. Morris on it, Judge.
On count one?
Yes.
Sure. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, go ahead.
Byron, you heard the officer's testimony, right?
Yes, sir.
Okay, and you and I have talked about this before about count one, right?
Yes, sir.
Tell the judge, were you intoxicated on that night?
No, sir.
Okay. Why were you asleep on that night?
I think I had a seizure on the machine.
Okay, and you are prone to seizures, aren't you?
Yes, sir.
And in fact, I think that's in the updated PSI that you do have seizures, and the probation department knows about that.
Yes, sir.
Okay. Now the officer says he smelled some alcohol. Why would he be smelling alcohol on your breath?
The only thing I kind of remember was I might have had an open container in the car. But I really don't remember.
Okay. So you admit that you might have been drinking alcohol on that night,
Might have, yes, sir.
but you don't think you were intoxicated.
No, sir.
Okay. And well, pass the witness, Judge.
All right, Mr. Smith.
So, Mr. Morris, you're saying that you had a seizure, and as a result of the seizure, you had passed out to the point that verbal stimulus and physical stimulus did not arouse you, correct?
Yes, sir.
Do you take medication for your seizures?
Yes, sir.
What do you take?
Careful.
How often do you take it?
Grams,
How often do you take it?
twice a day.
Twice a day. Do you know how alcohol affects that?
Not really.
So you have no idea what alcohol does to that drug. It's an anti-seizure medication. Yet you consume your medication twice a day and use alcohol at the same time.
Well, I don't drink like that, y'all, sir.
You don't.
No.
Well, you drink often because you were pled true to count 4, and you just admitted that you were drinking on the day that you were arrested. Right?
Yes, sir.
No further questions.
All right, any other witnesses with regard to count one?
No, Your Honor.
Any others rebuttal or anything, Mr. Smith? At this time, based on the evidence that's been presented, Mr. Morris, I am going to find count one true, that you did commit the offense of public intoxication on November 6th of 2025. So with regard to sentencing, Mr. Rojas?
Judge, Mr. Morris has been on probation since 2016. I think his probation has actually expired since March. It appears that from March of 2016, he was doing well until that first motion to revoke was filed in October of 2020. Notable, I think, as you can see from the updated PSI, at that time, he had some support of both of his parents, who unfortunately passed away, I think, the following year, in 21, when Mr. Morris at that point was sent over to SAFP relapse in March of 21. And then it looks like at that point, his parents passed away. He went from March 21 to December of 23 until the second motion to revoke was filed based on a new offense that was ultimately dismissed. And that motion was resolved by jail sanctions and continued on probation. And that brings us to this new motion, which is filed from, I think, in February of this year with the new allegations. So he's been on probation for 10 years. Other than this new PI, he hasn't committed any new offenses, even though one was alleged. That case was dismissed in 23. It's unfortunate, I think, that his parents passed away because it looks like they were the support for him. They were able to give him some guidance while he was on probation. He was doing well while they were alive. And even after they passed away, other than administrative violations and this new admitted drug use and alcohol use, which is serious. I understand those are violations of probation, but he seemed to be doing well until this new motion was filed. I don't know what we can do with him, Judge, because probation's expired. My recommendation, or I guess what we would ask the court to do is to let this time that he's been in jail serve as sanctions and let his probation expire.
Right, thank you. Mr. Smith?
Judge, I believe the recommendation of the probation officer is absolutely spot on. I think he's taken advantage of the court's leniency. We've sent him to SAFP twice. He's been in drop. He's done the moral recognition therapy. He has not gotten any benefit from all the programs that have been offered and completed. He blames the fact that he can't act like an adult because he doesn't have people to tell him what to do, but he's an adult. He shouldn't have to have people tell him what to do. He's been given every opportunity, and just letting it expire would be not justice in this case. We believe that probation should be revoked and he should be sentenced to time in TDC, understanding that he will get credit for the time that he successfully completed SAFP. So we would ask for a significant amount of time in prison.
Thank you, Mr. Smith. Mr. Block's here, and you have your updated report. Is there anything else that you would like to add, sir?
No.
All right, thank you. Mr. Morris, Mr. Smith is absolutely correct. I'm looking back at that original PSI, and the original PSI wasn't even agreed. It was a cap of 8 years in prison. And on that day, I gave you the opportunity for this probation, and you have had multiple. This is your third motion to revoke. So it hasn't all gone well. And the fact that you've been given those opportunities at SAFP twice and you're still doing what you're doing, I'm going to again I'm finding count 1 true, find that you entered your pleas of true to counts 2 through 5 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. You're lucky that the agreement in this is for a cap of 5 years. You know, the cap went down from the original, which is usually doesn't happen. I'm going to follow this agreement, but you're very lucky. I'm going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you. You can go back with the bailiff.
Thank you.